Welcome to week 13, where we are going to be talking about rights of the criminally accused in terms of a fair trial. So today we'll be talking about the right to counsel, the right to a fair jury, an impartial jury, and the right to a fair trial, broadly speaking. So let's get started. So the first case that we need to talk about is the Scottsboro Boys case, which is Powell versus Alabama. It's a 1932 case coming out of the state of Alabama. It is a case that I think it's important to understand the history of, so I'm posting a separate video that I would have played in class anyhow, so you can really understand the background of this case. I hope that you watch that before you watch the rest of this lecture, but in any event, please do watch it. The facts of the case are as follows. Two white women who were riding on a train. There were a bunch of people, probably about 24, that were riding a train in the South, and there were some white people on the car, there were some black people on the car. They weren't riding with a ticket, they were riding and just kind of skipping on freight cars. A fight broke out between the white boys in the car and the black boys in the car. And two white women who were also in the car claimed that several black young men raped them after this fight. When the train stopped in Scottsboro, a sheriff's posse arrested the black youths and jailed them in the county seat of Scottsboro. A hostile crowd gathered, wanting to lynch these young men and boys. Some of them were quite young. And extra security was necessary to prevent a lynching. Because they were charged with a capital offense, rape was a capital offense, or is a capital offense rather, the judge was supposed to, under Alabama law, assign them counsel. Instead, because no one stepped forward, he kind of did this haphazard thing where they got an old guy who hadn't, tried a case in a very long time and a real estate attorney, who effectively could not really help them. And in fact, one of the attorneys in one of the trials, because they separated them out a little bit, actually presented both the prosecution's witnesses and the defense case. There were a lot of strange things. The defense didn't make a closing, didn't make any commentary about sentencing, and so on. So at the end of the day, it's unsurprising that 8 of the 9 were found guilty and sentenced to death in Alabama in 1932. The case was appealed all the way up through the Alabama Supreme Court, which did not find an issue with this. Interesting fact, the NAACP and the Communist Party were the ones who funded the defense and appeals at this point once they found out about the case. It went from the Alabama Supreme Court and was appealed to the United States Supreme Court. And the question here was whether the representation that was provided was unconstitutionally unsound. In other words, was it effective assistance of counsel in a way that did not violate these boys' and young men's rights? Now, at this point, although they had not applied the Sixth Amendment right to an attorney paid for by the government, had not applied it fully to the states. The state here had its own provision. So the question is whether they applied it in a fair manner. And the Supreme Court said, in fact, they did not. They said it's the duty of the court to assign counsel to someone who cannot secure their own in these types of cases. But that duty is not discharged just by providing someone who can essentially fill a seat and say, I'm an attorney. In a capital case where the defendant is unable to employ counsel and is incapable of adequately making his own defense, it is the duty of the court, whether requested or not, to assign counsel for him as a necessary requisite of due process of law. And that duty is not discharged by an assignment at such a time or under such a circumstances as to preclude the giving of effective aid in preparation and trial of the case. As you will see in the other video that I posted, there are a lot of other problems with this case. They did all of this very quickly. They had one-day trials. There was a lack of presentation of evidence. Unfortunately, even though they got this case overturned at the Supreme Court level, they also had problems getting it applicable to all of them, and it wasn't until 2013 that the last one was finally exonerated, even though there was very little evidence, in fact, no real evidence other than testimony from the girls themselves. They could find no corroborating witnesses, and given the state of Alabama in 1932, it is likely that this was an instance of just blatant racism. That brings us to Gideon versus Wainwright, which ends up being our kind of seminal case in right to assistance of counsel. I'm going to post another video about Gideon that we would have watched in class. I think his case is fairly fascinating for a few reasons, not the least of which was that it was a handwritten appeal that he had made while in prison that made it all the way to the Supreme Court. Clarence Earl Gideon was charged with breaking and entering a pool room. Not a big case, and yet he requested and was denied counsel. This was a Florida case, because Florida did not provide free attorneys in anything but capital cases, and this was just breaking and entering a pool room. He was found guilty. He did not have the benefit of assistance of counsel, and he appealed the case all the way up to the Supreme Court on his own by handwritten appeal on prison letterhead. Fun note, I guess, if there is one here. Abe Fortas, a well-known attorney and future Supreme Court justice, was assigned to represent him at the Supreme Court. They gave him counsel at the Supreme Court, which they do with all pro se litigants who are representing themselves. So the question here was whether the old law under Betts v. Brady was good or not. Under Betts v. Brady, an indigent person charged with robbery in Maryland had asked the Supreme Court of the United States to overturn his conviction after he requested and was denied counsel paid for by the state. The court, siding with Maryland, had said that a free attorney was never intended by the framers, just the right to bring your own attorney. So in that case, the Supreme Court refused to apply Powell to the states or any kind of broad pronouncement. Here, though, the court did the extension and applied that law to Gideon and to all future criminal defendants. They said that governments spend vast amounts of money to establish a machinery to try defendants accused of crime. Lawyers to prosecute are everywhere deemed essential to the public's interest in an orderly society. Similarly, there are few defendants who, when charged with a crime, would opt not to hire the best lawyer if they had the money to do so. This, they said, speaks to the importance of having competent counsel on both sides. The fairness of trials cannot be secured, and defendants cannot stand equal before the law if the poor man is charged with a crime, has to face his accusers without a lawyer to assist him. So, like we talked about with the Fourth Amendment and the exclusionary rule, saying the Fourth Amendment means nothing without the exclusionary rule to back it up. Here, the right to a fair trial and the right to the assistance of an attorney means nothing if you can't afford one. So the court said that it was up to the states, in fact, to produce criminal defendants in their states with competent and effective assistance of counsel. So let's talk about what this looks like after Gideon. We have a couple of cases, I think I'm pronouncing it right, but we'll see, Asgeriner versus Hamlin and Scott versus Illinois, which developed the loss of liberty rule, which means that an indigent person charged with a crime has the right to an attorney if that crime, upon conviction, could lead to incarceration. Even if that incarceration is only 1 day, they have the right to an attorney. So that's when the right attaches, is when you are charged with something that can lead to jail time as a result of the crime itself. In Alabama versus Shelton, a 2002 case, the Sixth Amendment right to a counsel was found to apply even though the sentence was suspended. So even though a judge may agree to suspend a sentence, doesn't mean you don't get the right to counsel. In Douglas versus California, which happened right after Gideon, they said that the right to counsel extends through the first obligatory appeal. So that first line of appeal after the trial court, you still have the right to an attorney. That's why Michigan has a state appellate defender's office. But in Ross versus Moffitt, the court refused to extend the right of state-provided counsel in subsequent appeals. So it's only that first one. Now, an interesting case dealing with Michigan, Halbert versus Michigan in 2005. So another video that I would have shown in class that I think is really important, and I know I'm saying that a lot, but there were going to be a lot of videos this week, talks about just how difficult it is to actually effectuate Gideon's promise. It is very difficult for states to fund this. A lot of them have given it to the counties to fund. So depending on what county you're in a state might dictate some of this. There's just not a lot of money put towards this at all. And in Halbert versus Michigan, what had happened is the state of Michigan removed the right to free counsel on appeal if someone had pled guilty at the initial trial level. So they were trying to get out of paying for those first line appeals. And the Supreme Court said this was unconstitutional. As I'm sure many of you know, plea deals are made quite often as an attempt to forego a trial. And that doesn't necessarily mean that a person is guilty, but maybe that they just don't want to go through the trial, and so they plea. The Supreme Court was concerned with people being coerced into pleading and not having an attorney on appeal, and so they said that Michigan could not do this. So this leads us to this question of what is ineffective assistance of counsel, because what Gideon promises is that you have counsel, and along with Scottsboro, the Scottsboro Boys case, it means it has to be effective assistance of counsel. Well, in 1984, the court heard a case called Strickland versus Washington, which sets out the basic case for this. So on appeal, if you want to claim that you were not given effective assistance of counsel, you have to prove two things. First, that the counsel you were given made errors so serious that the counsel was not actually functioning as counsel. That these are not things that any normal attorney would do. They were just so defective that they were just practically making the assistance of counsel non-existent. And second, the appellant in the criminal appeals case here has to show that the deficient performance of counsel actually prejudiced the case. So what that means is you have to prove that your counsel was deficient, and you have to prove that that deficiency led to your conviction. If you cannot do both, then you cannot proceed on an ineffective assistance of counsel claim. This is a fairly high bar. This is not something easy to do. So otherwise, if you can't prove both things, and you have to prove the first thing to prove the second, but you have to prove both ultimately. If you cannot prove them, your appeal on this matter will not succeed. So we have a couple of other things to talk about, and not a ton of time or a ton of cases to talk about them with. One of them is the right to a fair jury. And the way in which we're going to attack that is, you can read what the Constitution provides as the right to right to a fair jury, impartial jury. But one of the issues with impartial juries and juries in general in the United States is racial composition. One of the problems, and we can think about the Scottsboro case in this regard, is that many times criminal defendants of color are tried by juries that are entirely white. In this case, what had happened is that a black man who was indicted for second-degree burglary had a panel of jurors that were provided, and the prosecutor used what's called a peremptory challenge to eliminate all of the potential jurors of color. So each side gets 2 challenges. One's a type of challenge for cause, like if you answer a question when you're being asked about being on a jury, saying, let's say it was a rape case, and you say, have you or someone else very close to you ever been raped? And you say yes, and you say, I don't think I could impartially decide this case, then they'll dismiss you for cause. But preemptory challenges are challenges that either side has that they don't have to give a reason for why they don't want you. They just don't want you. The question here is whether the prosecutor's use of the preemptory challenge to eliminate all the potential jurors of color violated the 6th Amendment and the 14th Amendment on the basis of race. The general rule is that a defendant does not have an affirmative right to a jury composed in whole or in part of persons of his own race. However, you cannot exclude on the basis of race. You cannot exclude jurors on the basis of race. A state's purposeful exclusion of minorities on a jury on account of their race violates the Equal Protection Clause of the 14th Amendment. And the state's privilege to strike jurors through peremptory challenges is still subject to the Equal Protection Clause of the Constitution. So a defendant, if they want to say, hey, wait, you're challenging that person, and I think you're trying to do this on the basis of race, you have to make a prima facie case saying that you believe that this has been done on the basis of race, meaning you have to give a bare argument as to why you think this was done. The state can proffer a neutral explanation for having challenged the juror or jurors at issue, and then the judge decides whether the defendant has established that there's been purposeful discrimination here. Now, this is quite often something that comes up later on appeal as well, so they make the challenges, they make the requests for determination, and then later it gets brought up on appeal. Let's talk about the right to media coverage, or the right to be free from overbearing media coverage. The case of Shepard versus Maxwell is one that you might be familiar with from the movie The Fugitive with Harrison Ford. That's what this movie was based off of, this case. The question in this case is whether the failure of trial court judges to implement procedures that safeguard juries from the media violates the 6th Amendment right to a fair trial. In this case, you had a couple of things going on. One is it was just a really sensational case in Cleveland at the time, and there was a lot of news stories about it. The judge was running for re-election and kind of seemed to enjoy the spotlight because, hey, you got to get your name out there somehow. And so there was not kind of the limitation on the media in the courtroom that there probably should have been. So the question was whether the jury was swayed by this media circus. There was constantly stuff in the news, and the judge did not put an embargo on them reading this. You can see some of the articles here. So they requested a lot of things, including a change of venue, and were denied. And the question is whether this was a fair proceeding. And the Supreme Court said, in fact, that it was not. That the media, has a right to report, but it does not have to be a situation where it's a media circus, and the judge must make provisions to keep the jury away from some of this. Now, on the other hand, we have the Richmond newspapers case out of Virginia in 1980. Now, in this case, the judge went in the completely opposite direction. Not only did the judge not allow cameras or recordings of the trial of any kind, but they said that the press in general, just a reporter, could not be in the courtroom. The court found that this violated the First Amendment right to free press, but talked about it as well as a protection of criminal defendants to have the press be able to report on proceedings. If the press cannot come in, if there is not the right of the press to be there and be a witness and sit in on trials, then the opportunity to have these trials really truly be vetted and made known to be fair and all of those things is not truly there. So there's a balance to be struck with this, to be sure. So, key takeaways. The right to attorney is not absolute, but it's a pretty strong one. I strongly encourage you to watch the other videos I put up, the ones about the Scottsboro Boys, Gideon, and then just criminal defendant or criminal defense attorneys, state defenders. Public defenders, I want you to take a look at those and think about whether this right is adequately being protected this day and age. And then the right to a fair trial includes things like a fairly selected jury, no media frenzy, but the media allowed in to witness. That is all for this week. I will talk to you very soon. We have an optional chat again this Wednesday at 2:30, our normal class time, so we can answer any questions you have about this or moving forward. I'm going to try and get through your outlines by then, but we'll see how far I get. And we'll go from there. And that's all I have for you this week, and I will talk to you soon.